Premises liability. That's a little bit of the lay of the land on those cases. So let's talk about premises liability. So, premises liability cases are slip and fall cases, right? And your recovery is against the landowner, and I talk about the MAI instructions here as well. There's a little bit of a distinction between an invitee and a licensee. So an invitee, and the standard is that there was a dangerous condition. The defendant was negligent in either creating, not remedying, or not warning of that condition. That your client either knew that the defendant knew or could have known, not should have known. Could have known. It's in the jury instruction. It's a distinction with a difference. So whenever I plead these and present these, we use the word could, not should. And then that your client didn't know about it, and that they were injured, approximately injured thereby. For an invitee, it's different. The owner or the possessor of land had to have knowledge, knew or could have, had actual knowledge of the dangerous condition, and the plaintiff lacked knowledge of that condition and could not have discovered it. And that is when someone's cutting through someone's lawn to go to the playground or something like that. I don't know if I've ever had a licensee case. I've almost always had invitee cases. Those are the bulk of the cases. The defendant has to control the premises. You'll have landlord cases. So, renters almost never have renter's insurance. So always be a concern if your client's renting premises. There's a whole line of cases about whether it's a common area, common control. If it's in your own client's apartment, you can't recover. If it's a common area that the defendant failed to maintain, you can recover, but you have to prove it's a common area or that the defendant didn't maintain it. If you're renting this porch and it falls off, that's not a common area, but you still get to go against the landlord because that's his structural issue to repair. I've had that asserted against me in a couple debt collapse cases. So let's remember too that that the plaintiff has to show that they didn't know about it. In any slip and fall case, you're going to have comparative fault on your own client. I always think when you're picking a jury on that, you think the jury already thinks that your client's half at fault, and then you're going up from there. So the question is, what do you do about that? What I try to do is I try to surrender to that and say it is what it is, and you try to acknowledge it a little bit. So there's different ways to do it. Sometimes in closing argument you say, "Yep, we're at fault. We're at 10% at fault," and you give the jury a number so that they get a number, and it's not going to be the defendant's 70% at fault. But acknowledging that and taking responsibility on your own side of the V is important, because you can't try to say the defendant was irresponsible and didn't own up their responsibility in creating that dangerous condition if you're not going to own up to your own part in it as well. So that's important to think about. So, and sometimes these cases settle at a discount because you have some comparative fault. So be prepared for that. Governmental entities are liable, just like, as I said before, for a dangerous condition of property. And these are typically sidewalk or curb cases. We're trying one of those on Monday and against the city of Chesterfield. So we'll see how we do. What about ice or snow cases? So in ice or snow cases, if it snows and is really icy and the defendant never did anything about it, you don't have a case and you lose on summary judgment because it's an act of God and it's a natural accumulation. So the only way to win an ice and snow case is if the defendant went out and shoveled or tried to get rid of the ice but did so negligently. So if you ever have your client come in and they say, I slipped and fell, and they never did anything about it, you got to say, well, you sure you didn't see someone shoveling over there, or you didn't see some ice melt over here, but it wasn't where you are because you don't have a case? Typically, they don't notice. I've had many times they say, no, there's no ice melt, there's no nothing. And then I got up, and then my pants were all dirty because I had salt all over my clothes. I'm like, well, they did it, but they didn't do it well. So you always have to prove that they did it negligently, and that happens a lot of time. Just 1 second, and
sure.
no,
Okay.
no worries, no worries. And there's always multiple defendants in these cases because the person whose store they are don't own the parking lot, and the person who owns the parking lot didn't pay the shoveler to come and do that. So it's always about identifying these parties, which is actually fine because then you kind of get them going in different ways. Every store has an ice and snow policy and a slip, trip, and fall policy. They'll never produce it to you. I've fought this so many times, but you always try to request that and try to get their slip, trip, and fall policies because all these big companies have them. Yeah, what's up?
I think you may have covered it, but in a situation where you have a natural accumulation defense, if there is a requirement to keep that area shoveled by the locality, they have no claim that it's a natural act of God.
I think that they still have the claim that it's an act of God, but you may have a per se ordinance violation claim. I've never had that. I don't know what ordinances require that, but
City and businesses in the city of St. Louis?
I don't know if you get that. I think the law on if you don't have evidence that they tried to clear and did it negligently, I think they could win summary judgment. That's my
Really?
experience. Yeah.
Oy.
Yeah. Exactly. Well, it is what it is. So